Good morning. Good morning. Thank you so much for joining us on a beautiful Saturday morning. My name is Haochen. I teach intellectual property and tech law at the University of Hong Kong. We have speakers who will be giving their talks on the other side of the world in New York and in California, which means that they will be presenting their papers on a Friday evening. And then all of you are attending the conference on Saturday morning. What a sacrifice, what a dedication. Thank you very much. I actually thought of, yesterday I was thinking of using generative AI system to print out images as gifts for your willingness to attend this event on a Saturday morning, but I thought of all kinds of legal risks that I might take. So as a risk-averse person and an intellectual property scholar, I thought I should wait for a while until I, venture to do so. I think at least I should wait for this conference so that we can explore all the complex and cutting-edge legal issues surrounding generative AI and intellectual property. So today, we have brought together 3 panels of distinguished speakers who are leading experts in this field. So our first panel will feature a keynote by Professor William Fisher. Professor Fisher is WilmerHale Professor of Intellectual Property at Harvard Law School. He is, at the same time, he is also the faculty director of Berkeley Klein Center for Internet and Society. He has worked on groundbreaking scholarship on intellectual property theory and policy. At the same time, he's spending a while with us at HKU as Chen Yutong visiting professor. We are really honored and privileged to have him visit here for a while and also deliver today's keynote. I believe that he's going to talk about how we can use general AI system to lead a good life and make our society much better. So without further ado, please join me in welcoming Professor Fisher to deliver today's keynote.
Many thanks, Haochen, for the kind welcome and introduction. I've known Haochen now for many years. I've admired his creativity, ingenuity, and courage in the field of intellectual property research. He continues to take on hard issues and explore them with thoughtfulness and imagination. So I will try to keep my remarks here to 20 minutes, which I gather is the guideline. My hope in this presentation is to provoke some discussion. So the topic of the presentation, title of the presentation is Artificial Intelligence and the Interests of Humanity. The provocation for this topic is the frequency with which both private parties and governments are currently proclaiming that their aspiration going forward is to shape the trajectory of AI in a way that will, as you can see from this example, benefit all of humanity. So this is an example from the mission statement of OpenAI. An analogous statement is made by the countries that participated in the AI summit in England recently. It's a lovely building, lovely historic building. Here's their mission statement. Similarly, as you can see, they assert that the ambition of any regulation of AI should be human-centric, or as they put it slightly differently, AI should be managed for the good of all. You can find similar statements in a variety of other legislative and private settings. So I began trying to put together some guidelines here on, well, what exactly are the interests of humanity that AI could advance? The legislatures, countries, and private parties don't provide much detail on this front, so I thought I might supply some. So, as Haochen suggested, I begin with the proposition for which there is support in long traditions in philosophy, psychology, economics, and now recently law, that there exists such a thing as human nature, which is difficult to discern, but stable, and causes people to flourish more under some circumstances than others. And specifically from this large literature, one can distill 8 affordances that foster the achievement of a good life. The first, of course, is being able to enjoy a life of ordinary duration. Equally obvious is the importance of health to human flourishing. Now things get more complicated. Autonomy. A long line of writers emphasize the importance to human flourishing of some degree of self-determination, the experience of, as well as the fact of self-determination. Next, engagement. There are 3 variants of this idea. They have in common the proposition that people flourish when they participate in the shaping of some important dimension of their common lives. It can be work. That was the original argument of Karl Marx. It could be political democracy, in which the principal exponents were the Commonwealth men in England, Alexis de Tocqueville, Hannah Arendt, Cass Sunstein. Or it could be semiotics, meaning participation in the process of shaping the cloud of symbols that define our cultural meanings. And here the relevant writers are the Frankfurt School, John Fiske, Jack Balkin, Barry Lessig, Sonia Katyal. Self-expression, a very strong tradition in continental legal theory, rooted in the writings of Kant, Hegel, and the British philosopher T.H. Green, less prominent currently in the United States, but increasingly appreciated as a component of the good life. 6, competence, an experience of being competent in whatever field one is engaged in. Turns out, social psychologists tell us through experimentation central to a sense of well-being. 7th, perhaps most obvious, affiliation. We flourish in community with others. We atrophy alone. And finally, privacy. So this is for obvious reasons, a deep, complex subject. Can't be grasped fully in a few minutes, but as a methodological matter, I think it's the right starting point in defining the interests of humanity. So if we then go back to the Bletchley Declaration, to which many countries in the world, including China, have now pledged fidelity, you see, to remind you, the phrase is human-centric and for the good of all. What does the good of all mean? Well, the most plausible reading of that proposition is that to the extent practicable, all persons in the world should be provided affordances of these 8 sorts. And so when fostering and managing AI, we should strive to achieve a sustainable condition of equal access to the preconditions of a good life. So sustainability then takes us in a different path. What does sustainability, read against the backdrop of this conception of the good life, mean? Well, it has the following dimensions, some well-known, some less so. First, best known is halting climate change. This is the fluctuations in the average temperature of the world over the last 400 million years. If we concentrate just on the last 170, this is not a sustainable trajectory from the standpoint of the good of the planet, but also from the standpoint of the well-being of the people who live on it. Second, balancing global consumption and renewal of fresh water. Again, this is not a sustainable pattern. It's also a highly unequal pattern. We need to rethink and stabilize a sustainable pattern of consumption of water. Food, similar troubling outcome. We are absorbing a greater and greater proportion of the capacity of the world to prepare for human consumption food, and it's unequal, radically unequal. This is access to animal-based products. This is the access currently available in developed countries. If all of the other regions of the world were brought up to that level, our global food system would collapse. So we have to rethink our relationship collectively to food. Resolving the global health crisis. Here too, there are major threats on the horizon and huge amounts of inequality. Sustainability of a flourishing life and culture requires correcting these. And finally, perhaps the most controversial, is we need to figure out ways of maintaining on the world a total human population and a distribution thereof that will facilitate the achievement of the first four objectives and enable all humans on the planet to enjoy flourishing lives. So we are in trouble currently on this score. This is the current projections of the total human population of the world. It's currently about 8 billion. Our guess is that's going to peak in approximately 2080 at 10 billion. And then because of the natural demographic transition that all major countries, including China, in the developed world have undergone, it will begin to arc down. But this trajectory is highly sensitive to tiny fluctuations in the variables. As you can see from the confidence intervals, we could be moving in this direction, which would be catastrophic, or we could be moving in this direction, which would be much better. Now, bearing in mind the importance of preserving on the planet opportunities for human flourishing, what's the right level? Well, we don't know, but it's surely less than 10 billion, probably less than 8, somewhere in the vicinity of 5, to be achieved not through, I hope this is obvious, genocide or starvation, as Malthus originally suggested, but through natural acceptance of the demographic transition rather than resistance of it. Okay, so that's a sketch in a few minutes of what seem the relevant components of the interests of humanity with respect to AI. Okay, so now, what are the opportunities and hazards of artificial intelligence against this backdrop? Well, we began with the existential threats, extinction and enslavement, about which there's been a lot of popular press. But insofar as this conference is focused on generative AI, well short of these dangers, I'm going to put them to the side for the moment. Sustainability. Now, instead of huge as existential threats, here we have opportunities. The opportunity specifically is AI could be hugely beneficial in achieving all of the dimensions of sustainability. Simple example here is the use of AI in cancer research is rapidly accelerating our ability to detect and prescribe treatments. Potential impacts on democracy, very large, and they point in different directions. So disinformation, simple, as yet hypothetical example, imagine an instance of ChatGPT run on the database of Fox News. This would be wildly supportive of disinformation. On the positive side of the ledger, Meta is currently using, and just this week spread to Instagram and Threads, a mechanism for using AI to detect disinformation and then to give users options to demote on their feeds information that's tainted. So, as you can see, from a standpoint of fueling democracy, AI could be horrific or it could be highly beneficial. Potential impact on meaningful work and self-expression. This is perhaps the area in which there's been the most discussion with respect to generative AI. My contention here is that there is no determinate, clear-cut application of AI. It could lead to greater alienation in the original Marxist sense, or it could lead to enhanced creativity. So to get a sense of what the possibilities are, I want to look backwards for a moment. Let's think about what has happened in the field of music as we have come increasingly to rely upon mass-produced art through machines. Has it corroded opportunities for creativity and self-fulfillment? As best we can tell, no, it is not. So the engagement of people at large and the process of creating and sharing music is stable and may even be going up with the benefit of technology. Okay, now this is worrisome, but the purchases and uses of pianos seem to be going down, but not if you look to digital pianos. Then if you look outside the US and music, you see that in China and India, the markets are even more robust than they are in the United States. And it's not just music, it's dance, film, photography, visual arts, creative writing. 24% of the US population engages in creative activities of these sorts, even though there are readily available, mass-produced, high-quality versions available to them. Okay, ceramics. I was provoked to think about this because Haochen brought me to the Palace Museum the other day, where there were truly remarkable forms of graceful handmade ceramics. They have, from a commercial standpoint, largely been displaced in the world at large, these handcrafted products, with commercially produced materials that resemble in utility and aesthetic the originals. So has this ruined opportunities for handcrafting and creativity? No, it is not. It turns out that potters continue to flourish, and indeed the market for their works is growing, not collapsing. So the central idea here is that the impact of AI on opportunities for creativity is indeterminate, and we should look for opportunities to tilt it in one direction rather than the other, and not look for opportunities to suppress it outright. So turning finally then to the law, how could legal reform help this project of turning AI in paths helpful to humanity and away from paths injurious to humanity? So, number one, mandatory elimination of linguistic specificity. What's relevant here is the distressing fact, now appears to be clear-cut fact, that ChatGPT is learning faster and therefore is better in English than in any other language. And this is exacerbating the quality of informational output throughout the world. If this process is allowed to continue, fueled in part by the inclination of bilingual people to use the English version, it will spiral, and we will create in the aggregate an AI system that favors the English-speaking world and disfavors all other cultures. We have to mandate in some way a change in the code that avoids this increasing linguistic specificity. Number two, mandatory attribution. So China and the EU are already moving in this direction. China, in its interim guidelines, has a mandatory attribution principle. The EU will have one as soon as the AI Act comes into force. The US does not. Currently on the table is a narrow version of attribution for benefit basically of actors, but it does not yet have a general attribution requirement. It should. Why? Because attribution is essential to enable consumers to know whether what they are purchasing is artificially produced or not. And if they wish to favor non-AI creativity, they can do so. It's also central to something we know from psychology and data. It's crucial to the sentiments of artists being given credit where credit is due and not to be blamed for things one did not create is a nearly universal human impulse, and labeling, attribution, is central to that. Next, copyright protection for the fruits of generative AI. Here's a big difference between jurisdictions. In China, there is a recognition recently of copyright protection for the fruits of generative AI. In the United States, there is not. And indeed, just last week, the Copyright Board reiterated this proposition in a case involving this photograph, which the user of an AI system said should be modified to more closely incorporate the style of Van Gogh's Starry Night, producing this work for which he sought copyright protection. The Copyright Office said no, because the work on the right does not partake enough of human input. It's the fruit of a machine and therefore not subject to copyright protection. Why is this a bad idea? Well, among other reasons, there are several, but here's the crucial one for present purposes. It will disrupt attribution. Why? Because people interested in obtaining copyright protection will lie about the degree to which AI shaped its creation, because otherwise they can't get registration. So it will fragment the possibility of a system in which we know how works are produced. Number 4, there should be no injunctive relief for non-permissive use of copyrighted materials and training data. This, again, is a big issue contested in over 12 lawsuits in the United States now. My view is that to unleash the sometimes enormously beneficial power of this technology, there should be no injunctive relief at the data incorporation stage. The model should be allowed to grow, but that does not necessarily mean that the owners of the copyrighted, often, materials used to train the model should not be compensated. When should they be compensated? When it's necessary in a specific field of culture to afford opportunities for creativity and health. With respect to, here's some examples, music and film, indemnification is probably not necessary. With respect to journalism, it probably is. Why in journalism? It's because the raw facts here is journalism is collapsing in the world. It's going down in terms of aggregate revenue in the United States, even taking into account digital subscriptions. Local newspapers are going out of business. Newsrooms are deteriorating. Reporters are being fired. And this is not just a US phenomenon, it's worldwide. To the extent we depend upon independent journalism to fuel information about democracy, this is catastrophic. So the legal side of this is the New York Times, one of the few remaining general sources of good reporting, is currently considering a lawsuit against ChatGPT to require compensation for ChatGPT's use of its stories. From the standpoint of copyright doctrine, this is a weak lawsuit because most of the materials being aggregated are facts, not subject to copyright protection. But from the standpoint of the health of democracy, we should be strongly inclined to favor the position of the New York Times. And finally, we should limit uses of artificial intelligence in ways that would threaten privacy and require anonymization. Now, I have to be careful about this because limitations, like this one in the EU Act, would, if generalized, impede socially beneficial research, including medical research. So anonymization to ensure that private medical data is not revealed to the public is central, but we should not regulate the activities of these companies so much that they are unable to do the crucial work of saving lives. Thank you.
Thank you very much, Professor Fisher. Thank you for sharing your thought-provoking thoughts about how to lead a good life and making our society better through the use of AI systems. And at the same time, we are very fortunate to have a very special guest speaking on this panel as well. Professor Christopher Yu is going to give comments on Professor Fisher's keynote speech. Professor Yu is John H. Chestnut Professor of Law, Communication, and Computer and Information Science at the University of Pennsylvania. He's also the founding director of the Center for Technology, Innovation, and Competition. Professor Yu is one of the world's leading authorities on law and technology, one of the most cited scholars in the administrative and regulatory laws, as well as intellectual property. He has authored 5 books and over 100 scholarly works. Thank you very much, Professor Yu. Please go ahead.
Well, thank you very much, Haochen. Can you hear me well?
Yes.
Fantastic. Well, it is a privilege to be here, having a chance to comment on Professor Fisher's fascinating presentation. My only regret is that I cannot be there in person, but I will have the privilege of being there in a few short weeks and have the chance to make up for my absence right now. But for right now, I will have to be content with simply appearing virtually and commenting on Professor Fisher's excellent work. So what I find this to be is really an inspirational extension of Professor Fisher's landmark 1988 Harvard Law Review article, which laid out the conditions that he viewed in terms for requiring for human flourishing in a preliminary basis, and applied it to fair use. And this article, or the presentation he made today, takes the same ideas and begins to apply them to artificial intelligence in a way that I think is also very interesting and very thought-provoking, as always is the case with Professor Fisher. And so in my brief commentary, I would like to say, first, there is much about this that is incredibly appealing. And so I really offer my comments from a standpoint of trying to engage in the work and to try to draw out some more of the insights, because I think that there's still much that we don't understand that I think Professor Fisher could share with us and help us enlighten us more. Focusing really on 2 areas. First is on the rationale underlying his theory, which focuses on the conditions that enable human flourishing. And the second is the implementation, his proposed legal reforms. I would like to take each one of these topics one at a time and offer my own thoughts about where I think we have more to learn yet from Professor Fisher's work. So starting first with the conditions that enable human flourishing, I repeat here the ones that he listed on his slide and that really played a key role in his 1988 article. And I found personally that while I think each one of these is very well articulated and it makes intuitive sense and are incredibly appealing, I always found myself, even in the original 1988 article, wanting more depth of rationale underlying each condition and really more grinding them together to try to understand that when they're in tension with one another, or when you have to make difficult choices, how do you make these choices? So if we have here 8 possible conditions that have to be furthered, anyone who knows who's looked at analyses knows it's impossible to jointly optimize 8 things at the same time, unless by some fantastic coincidence that they all line up in exactly the same way. And the key to making those trade-offs, to understand how to optimize them jointly, requires a fairly sophisticated understanding of what the justifications are for each. So one of the things that always struck me is, since Professor Fisher wrote his article in 1988, there is another major theory that comes along that's very similar in some ways, and I think it draws on some of the ideas that he laid out, which is the famous capabilities theory, really put forth by Sen and then later expanded on by Martha Nussbaum. And there's an interesting question. That list, I believe, is 14 capabilities, many of which overlap with Professor Fisher's. And I think understanding the rationale would help us compare the two, to understand why certain things made the capabilities theories list but were omitted from Professor Fisher's theory and vice versa, to start to understand some of the nuances and the animating principles that tell us how far to extend each of those ideas and as we move forward. In addition, as I mentioned, there's inevitable trade-offs. And in particular, there are trade-offs that are particularly difficult to make. Some of the rationales clearly sound in deontology, whereas others of Professor Fisher's rationales really are consequentialist in their heart. For example, the deontology, the self-expression condition was really focusing on Kant. Kant is the classic deontologist, and in fact is notoriously non-consequentialist in his approach. Many of the others, starting off with, say, life and health, are more clearly consequentialist, and there's versions of autonomy which cut both ways, and I could go through all of these different rationales. But to me, the process of grinding together the different conditions, understanding when they might be in conflict, would, I think, elucidate and add to the power of the framework that Professor Fisher has so powerfully advanced in ways that I think would provide insights that he probably understands intuitively or inside, but is less clear to those of us who read the work and don't have the same access he does. In addition, I find myself really wanting to see a more explicit connection between some of these values of these conditions and the values underlying copyright. The most often cited one, based on the text of the US Constitution and many rationales, is a consequentialist one, which is we don't protect copyright works for their own sake, but really to promote the creation and dissemination of creative works. But interestingly, these are by no means the only values underlying copyright. One that I've written on as well is issues around self-actualization, some of which has sort of a individual liberty, deontology aspects. Some of them are purely consequentialist. And, I find myself wanting to tie the conditions that he has identified even more explicitly to perhaps these two values, or even other values that the literature or Professor Fisher himself may see underlying copyright, to again understand how all these values serve not just a good human condition, but how the role copyright itself plays in drawing those connections. And then lastly, a new dimension to his work that I had not seen before is this drawing out this notion of connection to sustainability. And I think that sustainability is an issue on everyone's minds. It's clearly one of the seminal challenges we face as a global society. And we're all very gratified to see some level of agreement coming out of COP28, particularly at a point where it looked like it might end in utter failure. Again, without questioning the connection to sustainability, understanding more how copyright and intellectual property tied to sustainability, the issues that raised about access to clean water, access to food and food security, and the different aspects of population, would help me understand a bit more about how these values all tie together in ways that I think would add even more to the argument that Professor Fisher has made. So in terms of rationale, I find myself really wanting to learn even more from Professor Fisher, but I think the same thing is true in terms of the implementations. So, on its face, I find that there's a lot of intuitive appeal, again, to much of the proposed legal reforms. But I find myself, again, wanting more rationale, tying the conditions that he's identified and the values he's identified to the specific legal reforms he has in mind that I think would be really helpful. So connecting to the conditions identified, but in addition, really talking about how they connect to the purposes of copyright as an institution, and really, again, trying to understand when there's trade-offs, how we deal with them. Just to pick one example, the lack of injunctive relief, I think, is one thing very well developed in the SEPS context as sort of the standard essential patents context, as Professor Fisher pointed out. How they play out here, again, I think requires a little bit more understanding. Again, I gather it's more about the primary fight now is about the training data. And part of this has to be in a way that reminds me somewhat of Oracle versus Google, really thinking about the incredible benefits that follow from having the ability to train on these data, and the real practical reality that data sets of the size needed to train generative AI are relatively rare, and that if we deny people access to them, you'll have incredible limitations on people's ability to benefit from that. And the other thing that I still remember from when I was a young scholar, I was at the now defunct but then very well-known conference, Computers, Privacy, and Freedom. And I was asked by Fred von Lohman, then at the Electronic Frontier Foundation, what data could I show you that would change your mind? And to me, this became an essential part of the way I think of everything, because if the answer to that is nothing, then what we're doing is some sort of politics or ideology as opposed to academic science, because our idea should be to put out testable propositions, allow people to engage with them. And so what I find myself wondering is, in each of these cases of the legal reforms, are they always mandatory? Are there circumstances that might make us change our mind with respect to any of them? And I find this to be a very useful device in my own work to think through and to test my own ideas of my own slippery slope in my mind about how far I'm willing to take each of the rationales, and to really challenge myself to think more critically about what I'm doing. But really, I would like to just end by congratulating Professor Fisher on what I think is another very inspiring contribution, and to treat my remarks really as an invitation to give us even more of your mind, share with us more of your mindset, which I think would be incredibly valuable in us going forward to understanding the role of artificial intelligence and how it should shape and be shaped by intellectual property law. Thank you very much.
Great. Thank you very much, Professor Yu, for sharing your thoughts and comments. So I wonder whether, Professor Fisher, whether you would like to respond first, or we could open the floor for Q&A first? Okay, great, because we have a limited time. Okay, great. So let's open the floor for Q&A. We only have 5 minutes though, but maybe let's collect questions, and hopefully we could respond to the questions all together. Questions? Please raise your hand. Please let us your name and affiliation first, and then ask your question quickly.
Thank you for this opportunity. My name is Taoran Yisheng, a lawyer practicing in Beijing and also a law master in HKU LLM. I have to know and have a conversation with a big company concerning data annotation. Those guys who click yes, no, and illegal concerning all the AI output. And so I have a point of view under labor law. Those workers are not well educated and they're young and with low payment. So I think there is a self-contradiction that if we, in order to build a machine, we actually turn some workers at factory into machines. So their work actually very boring. Okay, so if you may share opinions.
Hello. Thank you, Professor Fisher, for your wonderful presentation. My name is Gigi Chow. I'm an investor in a tech platform that scrapes and understands intellectual property on the World Wide Web. And I'm intrigued by Professor Fisher's analysis on the rise or the stability of creativity. In what way has really the creativity not only remained stable, but it's basically changed forms, right? So in the old days, when we went to, an orchestra, before the prominence of streaming, before the prominence of electronic forms of, say, music, which is your reference point, music performances could be 4 hours or even 6 hours. And now we're sort of addicted to these kind of 30 seconds or even shorter versions of creativity, which more closely aligns to our mode of attention span. In what ways is the legal reform protecting older forms or even an attachment to form in creativity rather than creativity itself?
Do we have any other questions? So we actually have, yes, we could accommodate one more question.
Thank you for the keynote speech. I'm Jackie. I'm an engineer and a startup entrepreneur. So I'm doing the AI research for different kind of application. So as the entrepreneur or engineer, how could we, when we developing the AI application, how can we protect ourselves from the legal risk? That is my question. Yeah, thank you.
So due to time's constraint, we can only accommodate 3 questions. So maybe other students could raise the question during the next panel. So Professor Fisher, please.
Those are 3 excellent questions, and in the interest of time, I'll try to respond briefly to them. I entirely agree that fidelity to the ambition of maximizing opportunities for flourishing lives requires attending at a medium or micro level to the conditions under which particular sets of people work. One of the reasons why long-term, though not in the immediate term, the application of artificial intelligence to the process of disinformation, to the location and purging of false facts is intriguing, is to reduce the role of exploitative labor of the kind you described. But that's just one example. Proceeding on this basis throughout various fields of innovation and creativity is, I think, essential. The question about the changing character and role of creativity is very complicated. Robert Frank has a very interesting book called The Winner-Take-All Society, which describes, among other things, the concentration in smaller and smaller population of the capacity to make a living as a professional musician, and the decline in the large community that is able to be professional. On the face of it, that's a cause for lamentation. On the other hand, one of the reasons why I introduced these diagrams is to show that it's compatible with the preservation, indeed flourishing, of an amateur culture, which has arguably richer local social implications than performances in theaters. But what's the role of the law in dealing with that? Well, I begin with the presumption that I think Professor Wu shares, that if you don't need an intellectual property system, don't use it. And generally speaking, it seems unnecessary to deploy any form of intellectual property protection in order to sustain the amateur culture. So we should begin with the presumption of withdrawing law rather than reshaping it in that setting. With respect to the application of this methodology to the sphere of engineering, I confess, less to suggest, but one of the things I hope to begin to explore, despite my primitive capability in the zone of coding, is the extent to which Copilot and other systems are potentially fostering enhanced opportunities for genuine creativity in the process of creating code. and that something could be happening with the aid of artificially enabled software designs analogous to its power to facilitate, say, the writing of letters of recommendation or the preparation of musical compositions. But at present, that's just a hypothesis. Following the lead of Professor Yu, don't want to offer a general argument on this score without more data than I currently have. Thank you.
Thank you so much, Professor Fisher. I'm thrilled that the conference has so far featured such high-level discussion about AI and IP, so please do join me in thanking Professor Fisher and Professor Yu for sharing their thought-provoking, ideas. And so let's continue. Thank you. Let's continue our discussion and move on to the next panel. And the next panel will be moderated by Ms. Anna Wu, who is our honorary professor. Ms. Wu has made a major contribution to our faculty of law. She has been working with our colleagues on advancing our Center for Medical Law and Ethics. And she has also been engaged in a variety of other tasks. So we're so delighted to have her moderate the second panel.
I'll just start from here then. Haochen. Yeah. Well, thank you very much for inviting me, for having me, and for that introduction. I've enjoyed the speeches and the commentaries tremendously so far, and thank you very much to those who are here to enlighten us. I'm honored to be the moderator for panel 1. We have a panel of very eminent speakers, and you will learn from them as well as find the topics and the discussions extremely interesting. Let me just start by saying how disruptive is disruptive. You will hear a lot of that today, as well as from your own knowledge, reading about it. AI has turned IP, let's say, inside out, make it completely ununderstandable. Some say that AI creativity has been on par, if not exceeding human capacity. We have databases, particularly those with IP rights embedded in these bases, being gobbled up into its belly. And so our eminent speakers will address these issues, as well as to look at a degree of control that humans can have over this wilderness and to achieve some level of equity. So with that, let me first introduce the first speaker, Professor from Cornell. Just give me 1 second. We have Professor Frank Pasquale of Cornell Tech and Cornell Law School. I'm not going to go into his background at length because that will take away a lot of time. We prefer hearing Professor Pasquale on this topic, but I do need to say this, that he is the author of the Black Box Society, which is a landmark study in information law. So with that, let me ask you to welcome Professor, and he is being zoomed in. I think we have your picture on the screen.
Yes.
Can you just say something so that we know your voice is coming through well?
Thank you.
Great.
You so
So
much.
let's
that was such
welcome Professor Pasquale.
Great. Well, thank you for such a kind introduction. I'm really honored. And I also, I hope that you can see my slides. I will actually start the slideshow now, I guess. That's okay. And it's been terrific working on this project with Professor Sun, and to be introduced in such a kind way. And I will just dive in, and I'll also say, Haochen, if you want to cut in at the given slide, please do, but I can also present those slides as well, whatever you prefer. So this is, I want to start by talking about the generative AI supply chain, but actually before I start, I should also note that I think that it's really remarkable to think about the incredible powers of these systems and to think about our nomenclature and using them. We talk about expressive works and data creation and the content that goes in, the content that goes out. But I think also, I saw recently an artist saying that they didn't really like seeing their works just called data. They felt it was a bit dehumanizing. And I want to try to listen to that voice in this presentation, or try to express some of those concerns in this presentation. I also greatly appreciated the questions. The question in the chat by Ben Hopper about the problem of the sustainability issues raised by some forms of generative AI, and also the first question in the last panel about the process of exploitation of individuals in the making of this stuff. That even though it creates some amazing outputs, there are some very negative externalities, as chronicled by a report by Epic. And so to always keep that in mind as well as we think about this supply chain. But I think the supply chain metaphor is very useful, because we often think about how do we ensure that supply chains are not, say, using exploited or otherwise troubling practices. And I think I'm inspired in that way from the Lee Cooper and Grimmelman article, work by David Witter as well on the supply chain in AI is really inspirational here. What are the objections we're trying to deal with? Well, one of the objections, you saw on Twitter, this is a wonderful interchange between two scholars who have contributed a lot to our understanding of AI. Meredith Broussard's book, Artificial Unintelligence, is very good, and she also works on diversity issues in her latest book, More Than a Glitch. Both of them, and Mara Hicks as well, has contributed a lot to this field. And both of them were, pretty alarmed to see that their books were simply used to train AI that they had for years criticized. And, this type of criticism has really become passionate among artists. The text writers, I saw some very moving complaints in many places by artists by writers who signed on to a lawsuit. But artists are also promoting something called a create, don't scrape movement. They're saying that essentially, whereas many advocates of the technology are saying they are democratizing creativity and acting in some form as a Robin Hood, the protesters and those that are troubled by these uses are saying it's the opposite, right? They're saying that this is not the case. And I think that this is, and so this is part of those slides were about the normative rationales that are sort of driving a lot of the public concern here. I also think that there is doctrinal room for our intervention because of debates over copyright infringement at the learning phase, right? There's a lot of uncertainty. You saw that, for example, this is a quote from the Lemley and Casey article, Fair Learning, that owners and courts have begun to loudly and visibly push against the copyright system's permissive attitude toward machine copying. And it's almost a perfect storm of fair use indeterminacy here. Because on the one hand, if you think about cases like, earlier cases like TVIs or Google Books or these other things, at least in those cases, someone was pointing toward a work and they could say, well, I'm pointing toward the work and I'm in some way helping you via my search engine, et cetera. But on the other hand, whereas generative AI can entirely replace these works, or can in many ways aspires to do so, but on the other hand, you have this great deal of transformativity. And so, that to me is a really interesting sort of putting the equities or putting the fair use test. It's very hard to figure out where exactly that's going to go. And I know we're just about to hear from one of the superstars of the field about their views. And so I don't want to say that it's we have no guidance here, but I think it is really something to sort of think about how inequipoise these things are, given all of these lawsuits, and given also that, newspapers, I think, this is building on Professor Fisher's points, Terry's points about the news industry, that I think the news industry can be quite concerned that, what if people just have a chat GPT where they talk to it and say, well, hey, what's going on in Ukraine today? What's going on in the latest elections? What's going on in the weather, et cetera. And if it's just able to, have at it and scrape the people who are actually doing the work of finding out what's going on in Ukraine, what's going on with the weather, et cetera, then that's kind of troubling, right? And so I feel like this is an area where, we're going to see a lot more controversy. Now, part of our proposal, just to put our proposal in a nutshell, is to say that essentially, there's a necessity of control for plus compensation, in part because of these good arguments on both sides of the current AI copyright lawsuits. There may need to be some form of intervention here, if we want to accelerate the development of the technology. And I'm agnostic as to that, because of all the destructive aspects of it, but I'm going to, take it into as quite a possibility that, that's maybe where we're going as policy-wise. Control could be granted, at least some forms of control via opt-outs, where generative AI firms in exchange for immunity could avoid a long series of lawsuits if this were legislatively arranged, whereby they would allow certain creators to opt out, right? And we all know, I teach in privacy as well, and in copyright in so many areas, it's very few people often opt out, right? So this is not going to hurt very much at all, I don't think, so, but we'll see. We can debate that as this proposal develops. And also, we want to talk about compensation as fairness, as a form of fairness here. So these two parts, we'll have two parts to our presentation, one on control and the opt-out, and one on compensation. And so this is sort of in terms of the opt-out. Haochen, would you like to present these slides? And I can
Sure.
Yeah.
So this is the paper that I'm working with Professor Frank Pasquale. So I'm delighted to present the control part. And this actually, our proposal in this part actually is something that is in line with what Professor Fisher talked about earlier. We agree that there should be no injunctive relief for non-permissive use for AI data training process, but we need to find a mechanism to to make it happen. So this is in our opinion, a possibility of fostering this mechanism, and we call it a new safe harbor mechanism. This term might be very familiar with you. So this is a new system designed to empower authors in reclaiming their proprietary control of their creations through the notice and takedown procedures. So we can see that there are two kinds of copyrights that we need to protect. First of all, authors' right to reproduction. This is a legal right to prevent others from exact copies of their works, and also copies that are substantially similar to authors' works. And at the same time, we also have authors' right to prepare derivative works. So this is a legal right to prevent others to adapt authors' work into another format of new work. So for example, I think in the age of generative AI, we need to think about, adaptations of works that they might include a chatbot translating a novel into another language, an image generator creating a painting based on a photograph, a sound generator composing or performing a soundtrack derived from existing songs. So these unauthorized adaptations, we need to find a mechanism to deal with, and here we go. So next slide. So this new safe harbor system will allow, first of all, an author to make request the removal of their his or her work from AI systems that have generated an exact copy of that work. I talked about the right to reproduction, which has enabled authors from preventing others from making exact copies. So here is the mechanism. So after receiving such a request, an AI developer can review the request and then decide whether to remove the work from the training system or not, because the work, a particular work has been used to generate a new work, but the new work, is an exact copy of that work. So that this work, could be removed. And at the same time, the mechanisms could also allow authors to remove their works from an AI system that generates outputs that are substantially similar to the original works. So let me show you example. Next slide. So this is an example illustrating that works can be utilized to train AI models. At the same time, the output part could look exactly the same to the work involved. So if that occurs, authors can make a request to the AI developer in question and ask them to remove the work from the data training process. Next slide. And this is a case illustrating that the Mickey Mouse image can be used, can be adapted and then used as an image to, for example, to make a new film illustrating Mickey Mouse adventure in saving our world from the invasion of aliens, such and such. So if that occurs, again, the copyright owner of the Mickey Mouse can also make a request to the AI developer, requesting the developer to remove the, for example, the Mickey Mouse image from the system. Next slide. So the benefit of this mechanism, first of all, is to address the existing loophole in the copyright regime. For example, we actually have a safe harbor system under copyright law of many countries. This system enables people to request removal of works and then address the hosting liability of platforms. But this is about platforms hosting works uploaded by users and the associate liabilities. So this actually does not apply to generative AI situation in which generative AI system generated works instead of hosting works uploaded by users. So this is a mechanism to offer a solution, as we mentioned. Okay, it also empowers authors to stop infringing activities perpetuated by opaque intelligence systems such as generative AI system. And thirdly, it also functions to deal with the major problems with existing takedown procedures operated by some AI companies. Believe it or not, OpenAI and several other AI generated systems allow users to remove works or personal data from their system. But the removal process is really complicated and oftentimes impossible to achieve. So, and you can see that this is a mechanism that allows users to, authors, to quickly have their works removed. At the same time, it also provides authors with a more efficient and cost-effective alternative for resolving disputes. So this, as you can see in comparison to litigation, basically offers a much faster and also cost-effective means of settling disputes. So now I'm going to turn to Professor Pasquale to continue the presentation.
Thank you very much. Yes, I'm going to say thank you very much, Haochen. I hadn't introduced Haochen because you all know him. And also, I hadn't anticipated this intersection of speeches and deliberations. Of course, you know Haochen. I don't need to introduce him. And he has done a lot of interdisciplinary studies in the area of equity. So with that, I would just simply go back to Frank, and if you can continue. We are running a bit low on time, so if you can just go and quickly finish up on your points. Thank you.
Oh, thank you, Professor Wu, and I apologize. Thank you so much again for the introduction, and I will just go through this slide. So what I will basically do is say, and I will, to give a sense of where we're going with this, essentially, in terms of the compensation for copyright holders, we're also realizing that many of them are not going to opt out, right? Many of them are not going to opt out of the system. They're going to basically be just in it. And therefore, given that, we're going to need to think about how do we compensate them, given that their immense contribution to this overall system. So what I want to do, though, is before getting into that, give some rationales for compensation, right? And I think these rationales for compensation are really important because they help highlight the normative rationales for a more inclusive sharing of the bounty from AI. And we may ultimately go to a scenario like what Professor Fisher introduced us to with in terms of making this very sector specific, but let's think about it generally just to start with. Well, one rationale for compensation is that in general, the debate about IP has been going, I think, from an open versus closed to a labor versus capital dynamic. And what I mean by that is that if you look at sort of the opening battles of the copyleft and some of the great works from the 90s, 2000s, et cetera, a lot of the narrative there was of intrepid scholars and activists fighting big content and being aided by scrappy firms like Google and others in order to gain access to work. And I think that over the past 20 years, basically, we've gone from fighting big content to seeing that, in fact, big tech is often way more powerful and often has many schemes or plans in order to sort of use labor without compensation, without fair compensation. And so that sort of shift, I think, from an access to knowledge frame, which I say is still very important, but needs to be complemented by an awareness of the importance of labor's value is critical here. The second is encouraging production of human works. I think that if we think about the types of decisions about non-copyrightability of AI materials and some of the types of decisions that are out there about and just a general policy, as a policy matter, at least US doctrine seems to care about human-generated works. And I think that's a wise thing. And I think it's wise for a couple of reasons. One, we don't want humans overrun or overwhelmed by AI creations. And second, we've seen that the AI itself really relies on human beings. So there's recent literature on something called model collapse. And so if you have large language models that are learning from other large language models, that will lead to a loss of truth and a loss and what's ultimately called model collapse in the literature. And so we might want to try to stop that by ensuring that as LLMs start outcompeting humans in terms of creating content, there's some way to keep going, to keep supporting the substrate of human creativity and ingenuity and thought that is the true foundation of these LLMs. Another is avoiding unfair competition, because a lot of these entities are going to be essentially using, they're going to be deciding and in control of distribution channels. And so they may well promote their own AI-generated work over human work. And it would be, I think, a double injustice to, for example, allow that to allow that sort of asymmetry to happen. James Grimmelman has an article from 2016 called Copyright for Literate Robots, where he asked the question, is it really fair to have machines have better rules or more sort of more accommodating rules than human beings when it comes to copyright? And there's a very interesting recent article by Benjamin Sobel that's on copyright accelerationism that really throws into high relief. It's just posted on SSRN and throws into high relief this issue and this problem. And I think that unfair competition is a real issue. A fourth rationale is to avoid unjust enrichment. And one reason we go in this direction is because it may be that it's impossible to figure out exactly how you would fairly allocate any compulsory license fees for, say, the 186,000 books that are in one of the data sets, or for the millions of web pages that are in Common Crawl or something like that. But even if you could not think of any fair way to distribute the funds, merely putting up the speed bump of the funding itself and the funding demands themselves helps stop the unjust enrichment that would be predicated on a wholesale bodily appropriation of this work, often without any credit, without any compensation or any control. And I think that's particularly important because, going back to my earlier theme about big content versus big tech and the shifting landscapes of intellectual property normative foundations, that helps impede what has already been identified as exceptional power by AI players over the AI policy landscape. There have been exposés in Politico, other places about AI firms funding congressional staffers, et cetera. You see it in the executive branch too. It's a pretty remarkable story. And so that's one area as well. And the final rationale is enabling participation without exploitation. So the idea here is, you know, many of us are going to face, if there is something like an opt-out regime, many of us authors, and I consider myself an author, I think I've published, you know, hundreds of thousands of words, we're going to have to think about, well, do we take our words out and therefore not influence this sort of super brain that is highly influencing other people, maybe as important as Wikipedia or more important, et cetera? Or do we leave it in and just allow our work to be sort of exploited with no recompense? And what compensation does is it lets people participate. Because like it or not, it could well be the case that in 10, 20 years, where people get most of their questions answered will be in something like ChatGPT. Now, what will that world look like? It could quite possibly look like the dystopian fiction of M.T. Anderson in his novel Feed. And if you remember anything from my talk, I hope you will read M.T. Anderson's Feed, because I think it's quite an interesting prophecy about where we're headed with a lot of these AI tools. But I think that it is essentially something that is really quite an interesting sort of dilemma, and this can help ease the dilemma. Now, how are you going to do it? The methods of compensation. Well, with that, we're out of time. Well, no, not quite. But I do think that you could talk about shares and revenue or estimated firm value. One thing we play around with is the fact that OpenAI is worth $80 billion by some valuations. If you took $5 billion, that would compensate the 186,000 book authors at $27,000 a book. If you took $5 million, which is almost nothing to these firms, it's I think what they would pay a top-level AI engineer for a year. That would compensate the book authors by $27. You could take part of the revenue stream. You could do all sorts of things. And as someone with some experience in looking at healthcare financing in the U.S., you know, in various modes of pay for performance, et cetera, I'm very happy to contribute to that sort of perspective to this project. And we're going to be working on that in coming weeks and months. But my overall point here is just to say there's many methods of compensation, many benchmarks, but just giving some form of compensation, I think, is important. Even the expressive value of it is important because of all of the normative rationales that I've given before. Now, with this, I just want to thank again Professor Sun, Professor Wu, others here, you know, and I must apologize to Professor Samuelson and others that I have to depart at this point, but I will be very intrigued and interested in learning from the recordings of this event. And if anyone has any questions for me, I won't be around for the Q&A. I must depart, but I'm very happy to follow up via email or any other mode of communication. So with that, I thank you all so much. I will stop my share and bid everyone adieu for the night. So thank you.
Thank you so much. And you departed right at the point when people got very hyped up about compensation and money. So hopefully you will return. Thank you very much. Thank you.
Thank you.
We will come back when you are available for question and answer. The next speaker, and I have to ask Haochen first, do you have anything to add to the previous topic, or shall I just go on?
Please proceed.
Okay. The next speaker, we have Professor Pamela Samuelson, Distinguished Professor of Law at UC Berkeley School of Law. Many of you would have known about her works as a pioneer in digital IP. And of course, her recent publication include Generative AI Meets Copyright. With that, can I turn this over to you, Pamela?
Absolutely.
Thank you.
Let's see if I can
Welcome.
figure out how to. Thank you. Thank you so much. And I'm sorry I can't be there in person. I actually am wearing a Hong Kong jacket that I bought years ago when I visited. So it was nice to pull it out of the closet and find something useful to do for it. I'm going to actually talk about fair use and various defenses in particular in disruptive technology cases. I think it's important to sort of understand that generative AI is only the most recent of the copyright disruptive technologies that have essentially turn things upside down one way or the other. It's certainly disruptive because it enables new and really unexpected ways to use in copyright works. And not only does it have all these interesting ways of using material from in copyright works, but has been very widely adopted by the public and by many enterprises. So in case you didn't know, ChatGPT has over 180 million registered users. And of course, there are many lawsuits pending in the courts these days. But what I want to try to do in this talk is to review some of the prior disputes involving copyright disruptive technologies and consider whether there are any lessons that can be learned from those prior disputes for how courts might assess the claims against the generative AI developers. I like this particular quote. Copyright today is under stress. It's also under attack. The stress arises primarily from the rapid succession of marvelous new machines, miraculous enough to delight Jules Verne for copying and enjoying protected works in new ways. So in that way, they're a kind of boon, but by the same token, unauthorized copying of print, sound, and cinematographic works has become epidemic. Copyright owners' rights have been weakened, and the domestic and international traffic in piratical works has risen to flood tides. Sound kind of like dire, right? If the source of the stress lies in rapidly changing technologies and the political force of the attack draws from commercial and non-commercial interests, the assault weapon is the notion that some proof of harm is a necessary condition to protecting the interests of creative industries. So what is he talking about? Well, this was from a speech and an article that David Ladd, then the Register of Copyrights, made as part of his Brace lecture in the US. And he was worried about the unlicensed photocopying of journal articles by libraries for patrons, about videotape recording machines that allowed consumers to copy programs off of broadcast television, and home audio taping of sound recordings. And the people who were doing these kinds of copies were saying, hey, this is fair use because it isn't really harming any copyright market. And Ladd thought these technologies were causing harm and would have devastating impacts for copyright industries, and sort of inferred that there has to be harm if there's a large number of copies that are actually being made. So the first of these cases to find its way into the courts involved library photocopying. So Williams and Wilkins, a scientific publisher, sued the National Institutes of Health and the National Library of Medicine for making copies of individual articles from Williams and Wilkins journals for their patrons. And while only 8 articles were actually copied from the Williams and Wilkins did discovery, and this showed that the libraries had satisfied nearly 90,000 patron requests, and almost 1 million copied pages had been made. And what did the library say? Hey, it looks like fair use to me. So a majority of the Court of Claims judges upheld the fair use defense, but by a very deep split. The purpose of the copying, which is one of the factors in fair use cases in the US, was nonprofit scientific research. That's actually a valued kind of use under the US copyright statute. The nature of the copyrighted works, well, they were scholarly works, and under a gentleman's agreement between publishers and libraries dating back to 1935, copying for scholarly purposes was agreed to be okay. Only 1 article per request and requester was allowed to be made. If you wanted more, they basically say no. And Williams and Wilkins didn't show any kind of harm to its markets. It wasn't selling copies of individual articles, but only subscriptions to the journal, so that there wasn't any kind of market substitution. And the court also took into account that there had been evidence presented that a finding of infringement here would harm science. And the majority also said, look, Congress is kind of considering what to do about photocopying, and they're in a better position to really make a judgment about this stuff than we are. And so we basically kicked that particular can down the road. Now, the three dissenters had a totally different point of view about the fair use defense. In their view, the use was unproductive, and it was unproductive because in a book review where a second work actually gets created that builds upon some part of the first work, there was no extra work. It was just a plain copy. It was consuming the work for the purpose for which it was published. And whole articles were copied, each of which was copyrighted. And the court dissenters thought you should infer harm from a high volume of copying and sort of assume that markets were being harmed. And hey, they don't want to stop people from copying, they just want compensation. Now, Congress basically wasn't all that happy in having to deal with the library photocopying issue. The publishers and the Authors Guild were over here, and the educators and the libraries were over here, and they were like at war with each other about it. And so they couldn't resolve it. All they could do was basically put fair use into the statute and leave it to the courts to basically figure out what was fair use and what wasn't fair use. But also the National Commission on New Technological Uses of Copyrighted Works commissioned a study in 1976, commissioned a study of photocopying in 1976. And that showed that library staff had made almost 54 million photocopies of in-copyright materials for their patrons. And that didn't even count how many copies were being made by the library patrons themselves on photocopy machines. But it also reported that, hey, the publishers are actually doing fine, and you don't really need to reopen the issue about liability for photocopying. And then 2 decades later, the Second Circuit in the Texaco case decided that there was harm to the market because the Copyright Clearance Center had now made it easy for companies like Texaco to pay royalties, and the copy shops for curse plaques also were found to infringe. And the Copyright Clearance Center, again, served as an efficient mechanism for clearing rights to works. But of course, in the most recent of the cases involving photocopying of book chapters and the like, the Georgia State case, only a few of the uses were found to be infringement. Most of them were found to be fair, and a decade of litigation ended up with a really small amount of infringement finding. And so fair use basically kind of got things through. Now, of course, the next big fight was over videotaping. The trial court decided that that Disney and Universal City Studios were wrong, saying that the home taping of programs off broadcast television was infringement, and that court basically said they're all fair uses. The Ninth Circuit reversed and said they're all unfair, and the Supreme Court, in a kind of interesting 5-4 split decision, picked on just the time shifting and said time shifting was actually fair use. And then selling the machines to consumers was okay because there was a substantial non-infringing use. for that technology. But the court had a lot to say about harm. So one thing you sort of not realize is that claims of future harm that are speculative are not going to do the job. You also don't infer a harm just from the number of copies that might be made. You don't have to show actual harm or that future harm is sure to result. But the court basically said a use that has no demonstrable effect on the potential market for or the value of the copyrighted work need not be prohibited to protect authors' incentives to create. So in that particular case, the court was not persuaded by the many experts that Universal and Disney offered to say, oh, there's going to be harm in the future, and they didn't buy it. The third big kind of 1980s fight was over home audio taping. More than 1 billion copies were made each year by consumers. The Office of Technology Assessment did a study that basically said 4 in 10 Americans over the age of 10 were making copies of sound recordings that they liked, and they were sharing them with friends, and they were listening to them on portable devices and the like. Professor Nimmer says, oh, it's not fair use at all. It's like it's an unproductive use. Creative works are being copied, whole things are copied, and that satisfies demand for the original. And the whole the volume of copying should be really taken into account. And that never got actually to the courts because no individual consumer would be was willing to be sued, and it was hard to detect home taping. And then Congress considered exemptions or compulsory licenses, but here was DAT machines about to enter the market, and there was a lawsuit brought by some copyright owners in music and sound recordings, saying, "Hey, this, you may think that it has substantial non-infringing uses, but the primary use of this technology is going to be to make library-type copies of works, and Supreme Court didn't reach that, so we may be able to sue Sony for that." And what ended up happening is a settlement of the lawsuit and creation of the Audio Home Recording Act, which was kind of an innovative thing in its day, but because computer hard drives were omitted from that legislation, it ended up being really a dead letter. And so, but we have then the peer-to-peer file sharing cases held not fair use. And so taping of sound recordings, was a kind of mixed bag. I want to sort of just move on briefly to say that the Campbell versus Acuff-Rose decision, although it didn't have anything to do with disruptive technologies, it turns out to have had some important impacts in what I call the computational use cases. That's where, and why is that? Well, because many of these technology use cases a different purpose than the texts or images that might have been posted on the internet. So the kind of canonical case in this space is
Pamela, sorry to intervene. Yes. I need to rush you a bit.
Okay, I'm gonna go fast. So the Authors Guild versus HathiTrust case basically says it's a transformative use. Whole works were copied, but it was really necessary to do that, and the licensing markets were too speculative. Now, if you kind of like turn to how does that affect the generative AI lawsuits, the plaintiffs basically say, hey, copying without our works is infringement. It's not justified as fair use because of its commercial purpose and because its outputs are demand for human authored works. Some of them are using pirated books. And what we have then is the generative AI company saying, hey, like in the Authors Guild v. Google case, we have a very different purpose in using those works as training data. It's unprotectable stuff that we're trying to extract. We're not using the works as works, we're using them as data. They were mostly voluntarily posted on the internet. The outputs are rarely substantially similar, and there are many public benefits from this. So what lessons do we have from the cases? I think how the courts look at the market effects factor is going to be the most significant thing. There are lots of speculation of harm. I think that's not good enough. The large number of copies that are being made, also not enough under the case law. Is there evidence of actual harm or meaningful likelihood of harm? I don't see it in most of those cases. Getty Images is the best situation to defeat a fair use defense because it says it has an existing licensing market for use of their images as training data. But I think that the class action lawsuits are weak because there is no place for anybody to go to get a license from the class. So my conclusion is that based on these precedents, the generative AI developers have plausible fair use defenses, but of course every case has to be decided on its facts. We'll see what happens. These are very early stages. I know there is a great deal of interest in collective licensing. I think it's a well-intentioned, but really a bogus idea. So since I've run out of time, I can't say anything more. Thanks very much.
Thank you very much. We know we need to invite everybody back for a sequel. Thank you. And I need to go quickly to Haochen. If you want more time for tea, then Haochen has to be brief. So thank you, Haochen.
I'm glad that I'm standing between you and the tea break, so I'll try my best to be as brief as possible. But actually, there's very little left for me to say anything because Professor Fisher has laid out his own solutions, and Professor Frank Pasquale has also offered, thoughts about our project, and also Professor Samuelson has addressed the fair use issue. But I believe that there is one issue that hasn't been handled by the speakers so far is about the black box problems or the opaqueness problems caused by the generative AI systems. How exactly do we know the system has been operated? And so are we going to address these issues? So I will be dealing with this issue from the ethics of creativity perspective and try to offer some food for thought. So first of all, as you know that a lot of people have proposed that creativity is actually an individualistic idea, although copyright law promotes human creativity, but creativity itself is about individual authors. And so that's why creativity is also a black box or opaque process. For example, this paper concludes that even the most startlingly original creative work is still the product of a black box process. Although we have an increasingly detailed map of the human brain, we still have no very clear idea how cognition works, and in particular, how consciousness emerges. But I think I disagree with this idea, and I in my opinion, creativity is actually a social process rather than a black box opaque process. Why is that? So I have two ideas to share with you today. One is that we actually have a set of legal rules dealing with how authors can prevent themselves from committing copyright infringement. So the creation of works is not necessarily an opaque process. They need to follow legal rules, and at the same time, we also have ethical rules guiding authors to follow them to create works. So creativity is actually for human sociality rather than opaqueness. So you can see the from the instances of Ai Weiwei's sunflower seeds work. Professor Fisher knows it very well, and all kinds of things. And so let me talk about the legal rules first. First of all, we have the originality doctrine, which requires that copyright law only protects works of original authorship. So we have two, standards for judging originality. One is independent creation, meaning that an author should have created a work by himself or herself. At the same time, the work should have some minimal degree of creativity. So I think this requirement shows a rule for promoting ethics of creativity. Do not copy. Create works on your own. So this is the first golden rule for promoting such kind of ethics. At the same time, we also have the infringement test, the test for analyzing whether the right to reproduction has been infringed or not. So first of all, we need to consider whether the defendant has had access to a work, and secondly, whether the defendant's work bears substantial similarity with the plaintiff's work. So from this test, there's another golden rule for promoting ethics of creativity. Do not create works that look substantially similar to others' works, right? Okay, so let's talk about another legal rule or legal doctrine that, this is actually fair use, a legal doctrine that Professor Samuelson has addressed earlier. So as you know, the fair use allows, it's not for authors, it's for users to use copyrighted works without consent from copyright holders, at the same time without providing remunerations to authors. And these are the 4 fair use factors under the US Copyright Act. But I think there is a very interesting thing that we have to bear in mind is about making attribution to authors while users make fair use. This is an effect that has been ignored by many people, but I think I want to highlight today, when you make fair use, you also need to make proper attribution to authors, giving them sufficient credit for their contribution. So I think one of the things that we have to bear in mind is that bad faith is actually a factor that might determine the fair use outcome. For example, this is a decision showing that bad faith may weigh against fair use. So if you deliberately, remove authors' names from the work that you have, cited, then it's something that proves that it's bad faith, right? Okay, and also, scholars have already concluded, some of them, I should emphasize, all users of copyright materials, whether fair use under a license or use under other exceptions, should include a proper copyright notice and attribution. So there's a golden rule that we could, draw from this part of discussion is to make fair use of a work with proper attribution to its author. So it should not be a, black box process. We need to make, make it clear. Okay, when you, for example, when you create a new work, for example, a research paper, when you cite others' work, you should, in the footnotes, for example, show attribution to the relevant authors. And let me quickly talk about ethical rules, which will make the creativity also a social process, not a black box problem. So plagiarism is an ethical rule that I want to highlight now. Okay, so plagiarism, as you know, may not necessarily lead to legal consequences. For example, if I found a student of mine, committing, who has committed plagiarism, I might not bring the lawsuit against him, or I might not make a call to the relevant author, encouraging the author to sue my student. So oftentimes there will be instead ethical consequences. For example, peer pressure. students might not be doing well with his or her peers, and there will be moral blame, attributed to that student, and that could lead to moral punishment, according, for example, to a school's code of conduct. So being accused of plagiarism is one of the most stressful things that can happen to students during their university time. So there's another golden rule that we can, draw from this part of the discussion. Do not plagiarize. Make your work, in the sunlight, right? So another, again, the ethical rule is about attribution. Attribution could be a part of the fair use analysis. It's part of legal rule, but at the same time, I think attribution by and large is an ethical consideration, whether you are willing to acknowledge others' effort or creativity, and whether you're willing to help others find the original work by showing the sources in the footnotes. And it's also a determination to prevent plagiarism by itself, right? So there's another golden rule that we can draw from this part of discussion again, okay, for promoting ethics of creativity. Provide proper attribution. Okay, provide author's name, the title of the work, the date of creation or publication, or any other relevant copyright information, okay? So what about the generative AI system? Generative AI system, as far as we can see, promote this kind of opaqueness of creativity. So for example, there are 3 stages of a generative AI system, the running of the system that I can see. First of all, collection of data for training AI models. It's so far completely a black box process. First of all, you can see that AI companies have bypassed permission from copyright holders. Let me show you an example. The so-called LAON, the large-scale artificial intelligence open network, is the largest data set of training images. As of October 2020, it houses 5.85 billion training images. But this data set owner hasn't really sought permission from the relevant copyright owners. I'm pretty sure that most of them are still under copyright protection. And secondly, we also have AI systems that haven't really disclosed their source of data. For example, OpenAI is the best example. It literally copies everything from the internet, but really hasn't really, disclosed source of their data. And then when it comes to the second stage, utilization of data to train models, we don't really know how they process copyrighted data. And it's also due to that black box process, AI companies have largely avoided paying royalties to copyright owners for making copies of such data and storing data as well. Okay. And with respect to the third stage, generation of new works, we don't know actually whether they're, the works generated by AI system would be copyright infringing. These are the examples where it's still quite a puzzling process. And also Professor Fisher mentioned that the misinformation or disinformation problem, and also the deepfakes phenomenon, whether the works will constitute will contain misinformation and deepfakes. We don't know how the process will lead to that stage. So how can we address the black box problems caused by the generative AI systems? If you agree with me that creativity is by nature a social process, we should make it, as as public as possible. Okay, so I think first of all, a solution could be require AI companies to develop filters to monitor and eliminate outputs that may infringe copyright. So this could be the very first solution that we could be relying upon. And some of the legal considerations that we could have now is that we should prevent AI system from making exact copies of works, from making copies that look substantially similar to authors' works, and prevent AI systems to make public performance of works without authors' consent. But there is also a fair use consideration here. It's complicated, but we could discuss it during Q&A session. And there will be technological considerations. I think it's this kind of filter system is still, quite likely to be implemented technologically. I can share with you the publications discussing how we can achieve that technologically. And there are other solutions, but due to time constraints, I want to quickly skip them. But I'm pretty sure that I would like to share the other solutions with you after I finish this paper. And I've already, for the time being, they're kind of as trade secrets, although I have already reviewed them to Professor Fisher. So far, you can see that some of the, as Professor Fisher mentioned, that Microsoft's Copilot program has already sort of trying to deal with the copyright infringement issues, and so shielding consumers from the potential copyright infringement liabilities. So has OpenAI. They have sort of launched this so-called copyright shield program. But I think there's a limitation with this kind of program, because instead of let copyright infringement occur in the first place, it only deals with what will happen after copyright infringing activities occur. So I think we should develop a system to prevent copyright infringement from occurring in the very first place. As I said, technologically it's feasible, and there are legal requirements that AI companies should follow. So suppose we have this kind of filters developed, I think we could address such a legal dilemma. So here is an image created using Stable Diffusion with the prompt: Mickey Mouse as a lawyer sitting at the desk with a bookcase of law books behind him. What a cute image. But it will cause copyright infringement concerns, because the Mickey Mouse image looks identical to or substantially similar to the copyrighted Mickey Mouse image. So if there's a filter, then this image could be, sort of eliminated in the first place, right? Against the same for this image. But what if we have a filter? Then then we could probably create a Mickey Mouse as a judge image like this, which is less likely to infringe copyright. And if you want to create a Mickey Mouse as a politician, this could be, and with a filter, this image might be less likely to infringe copyright. And if you want to, so we create an image about Mickey Mouse being a president. Okay, so with a filter, I think this image is likely, these images are less likely to infringe copyright. And ultimately, if we bear in mind fair use, these are the images that could be created with a filter. And this, Mickey Mouse as a present image, would absolutely constitute fair use. As Professor Fisher knows, that there's this kind of, Obama Hopper poster case, poster case, and so I believe that we need to adopt rules for promoting ethics of creativity, and we need to build generative AI system without building black boxes. So if we can adopt all of these legal rules and ethical rules, we could celebrate ethically and legally with an image of Mickey Mouse on the celebration cake. Thank you very much.
Well, thank you very much, Haochen. Wonderful. And you would find that very interesting. But let me just say that I was very nervous moderating this panel. You have such interesting speakers that I was nervous because we were giving them so little time. So let me ask Haochen if he could get them back, including himself, at some point, because they have such interesting and fascinating material. So thank you again, Haochen.
Have some extra minutes.
Yes, I have your permission, and I'm going to eat into your coffee time, but still, we're not talking about a lot of time. So let me ask you to raise your hand for questions, but please make clear the speaker that you're directing the question to. I believe it's in the middle first.
Yes, my name is David Locke. I'm the judge in charge of the intellectual property list of the High Court of Hong Kong. At least this is one of the hats that I'm wearing at the moment. And the first lesson I learned this week is technology doesn't always work. Now, I want to share with you some of the thoughts that I've been attending some of these conferences, including one of the forum for judges around the world in WIPO last month, is that we have been thrown with a lot of questions, already simulating questions. We are more interested in answers because we are trained. Our job is to provide answers. I take the view that the judges are not in the best position to answer these questions. How would we able to, now the beauty of the common law system is that we have president. Now with these kind of cases, we don't have president. Then we are being forced to take into account other considerations such as policies, that sort of thing. How can we decide without listening to what the other stakeholders would have to say? I may answer the question one way, but perhaps after listening to what Professor Fisher said about the sale of guitar, I may have different thought. So how would the judges be in the best position to answer this question? So the way forward must be legislative amendment. Now, so that these matters can be fully debated and the public forum, stakeholders being listened to, and then we have the answers. But why should we be the first jurisdiction to legislate? Now, for example, we legislate on fair use. If a different jurisdiction legislate a wider definition of fair use, it may affect the whole ecosystem in the sense that, it may move, the AI business may go to the jurisdiction which are wider fair use defenses. So I think harmonization of the law is necessary. But taking into account the present political tension, I'm rather pessimistic. The end result is that we poor judges will have to be faced with very slow process in the legislative amendments. The court would be thrown with cases which we are ill-equipped to deal with. For example, comparing the Mickey Mouse, how will we be able to differentiate whether it is substantially similar from the, this is making it very difficult. So I rather than perhaps, I'm apologize for airing my frustration, perhaps, but I think certainly I would like to see the way forward. But it's very interesting to see. But as you say, this is quite new to the Hong Kong courts, as to many other courts in the world. I would be interested to see and to listen to what I think we as judges will simply have to keep up with this. Thank you.
Thank you very much. Although I have liberty to eat into your coffee time, but I'm going to do this. I'm going to welcome your saying that perhaps things lie in legislation. Perhaps we need to look at stakeholders' engagement and so on. So it's a very complex issue. I will invite the speakers to respond to that if they can today. If not, I'm sure they will be happy to respond later on in writing. But let me go on to the second questioner first and maybe gather 3 or 4 questions and stop there and see if we can get some degree of response. Okay, I think the second questioner is right next to you, Judge.
Ronald,
sorry. Yes, please go ahead.
Ronald Yu, I have a AI startup focused on IP commercialization. I would actually like to add to Judge Locke's question. In that question specifically for Professor Sun and by extension, Professor Pasquale, have you any thoughts on enforcement mechanisms? Because authors will have a very hard time trying to monitor the space. Again, there is the problem of substantial similarity, and going back to authors' problems, if they have to take legal action, the cost could be extremely high, particularly if multiple jurisdictions are involved. Thank you.
Yeah, I'm going to ask the speakers to respond to you later on because they seem to be in a similar package. But I believe there is another gentleman next to the judge here who had your hand up before. Do you want to speak now? Right next to David.
Oh.
Yes. Oh, okay, okay. Then I'm going to cut you out.
If I may.
You have to do it very quickly because we've got.
Yes, that would be very, very simple. Yeah, it's Anthony Tong. I'm an IP practitioner here. We've heard about the fair use system, principally from the US. So I'm not sure that's not supposed to be ascertainable and certain with a certain degree of certainty. I'd like your thoughts as to how certain is that with fair use when every case is depending on its own facts and is really not helping much. But that's it. Thank you.
Yeah, I think probably Pamela would wish to respond to that. Let me just ask the last question here before we wrap it up for answers.
Hi, my name's Hayden. I'm a tech lawyer and an IP novice. My question is for Professor Sun. Interesting idea you raised with the takedown notice. It's one of the answers. You mentioned that will promote the sort of cost effectiveness for the authors. My question actually relates to cost effectiveness for the AI system operator. So if we look at the LLMs, large language models, they are essentially a one-way machine, isn't it? Right? You train large groups of data. You turn them into sometimes call encodings, and then they make certain cogent suggestions, outputs, right? So if you could indulge me in using analogy, if one day sugar is held to be illegal, right? And we go to this baking shop and ask them, well, take down notice for sugar over your cakes, right? Is that practical? Are we asking, is there a way for the cake shop to take the sugar out of the cake, or are we asking them to pre-bake or rebake all the cakes, right? So hence the cost effectiveness of a takedown notice to these sort of models. Will that turn into in effect a recall regime, and what would be the ramifications? Are we encouraging these AI operators to lie about provenance or sources of the data, which you mentioned is still a black box, or filters like you mentioned? But then that sounds to me trending towards some sort of censorship system for the authors. So if you can hear your thoughts on that, thank you.
Huge issues, although Haochen said, collect as many questions as I can. I'm going to stop here. Firstly, perhaps I can invite Pamela to respond to the litigation issues first, very quickly. Do we have time? Okay. Okay, well, is Pamela here or not? Okay. Then is Frank here?
No, Frank
is gone. He said he might come back, so he's gone too. That leaves Haochen to answer all your questions. If not, you can direct.
Okay.
Leave it on the website or something.
I'm really, between you and the, standing between you and the coffee break. We have a lot of coffee, tea, and refreshments. Great. Thank you so much, Justice Locke, for sharing your thoughts. And I do believe that it is really high time for courts and judges to think about how such cases should be handled by the judiciary, because as you can see in the United States and in Europe, many authors or associations representing authors' interests have launched a wave of lawsuits against those amazing technology companies. So what they try to rely upon courts to protect their interest first. This is because legislative process is always very slow and hard to achieve because of all kinds of bargaining process, and also a political process. So, and judges have a unique role to play by interpreting, the flexibility that already embedded in the legal system. For example, fair use, fair dealing, although fair dealing could be a lot more rigid than the US fair use system. So I believe that, for example, and then so actually there are already judges, for example, in the United States, have already shared their concurrence with you when they, for example, deals with deals with issues about whether AI systems should be recognized as inventors. District Court and Federal Circuit Court in the United States have already made their opinions, saying that, well, this issue, at least, they should make deference to the legislature, inviting the legislature to step in. So they have already written down in their opinions. And let me respond to other questions as quick as possible. With respect to the enforcement mechanism, I believe that the current safe harbor that we are drawing upon, for hosting liability, has already, demonstrated it's a very effective system. If we could make this system legally possible, there is a way that copyright disputes concerning data training and output part could be addressed rapidly, and protecting interest of various stakeholders, authors, AI generative companies, et cetera, et cetera. So it is a matter of how we could design such system. And with respect to that gentleman's question, I think this is really a plausible concern, whether, for example, AI companies will really, for example, lie or even hide their information from even being disclosed. But I think we could, impose legal penalties for non-disclosure. And remember, there will be whistleblowers who can always help us. For example, the Facebook case really illustrates that, if there's a whistleblower who reveals information, there will be deadly consequences for people like tech CEOs. And also, if we impose legal penalties, and that will become deterrence against non-disclosure. And companies will also think about, public relations, considerations. And I also think that the takedown procedure and also the filter system could also serve as an opportunities or platforms or vehicles for us to open up dialogues with AI companies. One of the reasons AI companies is not willing to disclose information about their system is that there are currently no mechanism or legal requirements that push them to disclose information. But if we place some operations in running, then they are legally required to respond, right? Okay, whether this piece of work should be taken down from the system, how they should review and how their system is running, right? So information will be disclosed as long as we have legal requirements or ethical requirements imposed upon them. So it will be a lot harder for them to operate such black box systems. Thank you so much. So time for proper tea break.
Thank you very much, Haochen. I know it is difficult for one person to answer all your questions adequately, but to the judge, I'd like to say thank you for taking on the cases, because at least it gives us a fighting chance to develop the law, to have new laws made and interpreted. And I know law reform in Hong Kong is notoriously slow, but I wish everybody better luck. But one of the things that I'd like to say is that in any area of law reform or any kind of engagement exercise, negotiating power, level playing field are really significant factors. We've all found those who are most vulnerable are the least resourced. So whether it be litigation or otherwise, we need to look at systems that cater for that: equity, balance of power, and access.